SJC-13749, Quinteasha DosSantos versus Beth Israel Deaconess Hospital, Milton, Inc., et al.
Okay, Attorney Sobczak?
Sobczak, yes. Good morning, may it please the court. Attorney Chris Sobczak on behalf of the plaintiff. We're here for actually one step before the last case you heard, is asking the court to establish or to clarify the fact that medical records, which are deemed confidential both by federal and state law, should remain confidential when plaintiffs or victims of injustice seek justice in the court system, and they should be impounded. In every case when an impoundment is sought, especially nowadays where medical records and electronic records are no longer 1 or 2 page. When you have a single 2-sentence note, often that is 17 pages of records, because the cut and paste from medical records has the patient's history, his medication, everything else. And in court, again, with the technology, all the records are available online. So I understand that historically, people have not done that. Probably you have cases before you that there are dockets with medical records that were not pushed down beforehand. I have lots of gray hair, but I've only been practicing for not that recently. And since I've been practicing, the technology has been changing and changing and changing. And nowadays, with the technology available, the medical records themselves are becoming more and more prevalent. They are more and more voluminous, and they're available on the court system.
Counsel, sorry, can I interrupt and go back to the legal argument, yes, which I understand that that's an important piece of it. I want to understand precisely your argument. So is your argument, normally, as I'm sure you know, there's a balancing that happens with impoundment because of the public's right to access and litigation and understand what's happening in our courts, and it's a really important value on both under our common law and our Constitution. So are you saying in every single case of medical records, we no longer do that balancing and all medical records are necessarily impounded? Or are you making an argument that that we do that balancing, and in general, it should always come out in favor of impoundment, barring special circumstances or some special reason why there's a public interest in the records?
My argument is not to uphold or overturn the impoundment rules. I think good cause is the proper standard. It's been applied all across the board. My argument is that as the court's own form that's been used for ages, and it's in the docket record appendix, page 110 to 111, medical records by themselves are good cause, just like psychiatric records, just like grand jury testimony. Those things alone should be good cause.
And on what kinds of circumstances would you agree that it could be appropriate not to impound medical records?
When a party whose plaintiff it is chooses to disclose them. When somebody wants to use a medical record in their complaint and they say, I don't care about this excerpt being publicly, then they're open. The patient should have the control of what they choose to disclose. The patient should not have to be victimized twice just to seek justice, saying, well, if you're gonna seek justice in the court, you're at the whim of a single judge to see whether or not the price to get potential resolution is you have to disclose your entire personal history to the public to see. Because when it comes to good cause and the judge says, no, I don't see good cause because it's just as medical records, even though you're a 19-year-old girl that has a history of other procedures that you may not want in the public.
But here we don't have any, to be clear. I understand that your argument is about medical records generally, but we don't, the judge provided an opportunity. He ruled without prejudice, and he said, you can give me a more particularized motion for impoundment, but you opted not to do that. You did not provide a more particularized motion.
Correct. The basis for the impoundment here is that there wasn't any specific psychiatric records that are extrajudicially. It was medical records alone. The fact there was a 19-year-old girl that didn't want her history of medicine, her prior involvements out in public to see for everybody to click on it online.
And she's got some of it in, right? Although the offer of proof is very general and contains no records, right?
Correct. So there is a distinction.
So and how does, you see, it's like a chicken and egg, though. So there's no, they've got a job to do, too, to defend their clients. You're not putting in any records. You're asking them to be impounded. They've got to defend themselves from a malpractice suit. How do we resolve all of that?
Well, they have the medical records. They're just not in public form. And in this case, and I'll get to the end of the issue.
But they're not going to be allowed to, are they allowed to use them? I'm trying to understand practically how this is going to work, both at the medical tribunal and in court. under your theory.
Well, in court in this case, because the court did not allow her to impound, she chose not to proceed. I have other clients that
But
may
you're saying you want us to reverse that. I'm just trying to get a sense of how this is going to work in the real world. So help us out here.
As it works in every other case I had, except for this one instance, the court allows them to be impounded. During discovery, the parties use their records back and forth. They can use them for their experts. And at the time of trial, when we have the medical records go to before the jury, they are impounded. They're used in trial. Information about them is discussed in open court. It doesn't prohibit you discussing what the condition is. It's just the actual records itself. The source documents that are protected by HIPAA and by state regulations, they're impounded. And at the end of the case, they're returned or destroyed.
So we're not allowing the best evidence of the medical record, the best evidence of treatment. We're going to only allow commentary on it. Again, I'm not a trial guru.
Everybody's seeing it, Your Honor. So the plaintiff says the medical records, the defendants have the medical records, the court has the medical records, the witnesses have the medical records. The only people that can't see the medical records is the general public. That's what impoundment is. We're not talking about a sealing, like was discussed earlier, or a protective order that controls who, what she can do with these records. All that impoundment does is takes away from the public file, which I do agree, there's a reason why we're being recorded here. Justice should be in the open, but some things, as the court has agreed by establishing the impoundment procedures, some things should be protected. For example, grandparent.
Is the offer of proof in the public record?
The offer of proof is. So the arguments are.
You could have put whatever you chose from the medical records into your offer of proof to the extent that it supported your expert's opinion. Is that right?
I could have, correct.
Right. And that wouldn't have raised any problem. You would have still controlled the pieces that your client did not want to have put to the public record.
That would require taking some of the medical records and making them publicly available.
Or just putting a narrative in the offer of proof, which I have seen many times, right? An offer of proof can be quite detailed and refer to things that appear in the medical record. You did not do that here.
The expert letter does provide a narrative. The expert letter provides a narrative of what the providers did, just doesn't identify specific providers. And that was what the defendant's argument was, that without the medical records, the narrative from the expert, which does provide a somewhat detailed explanation of the procedures, what she was on, what procedures were done to her, what happened, and how it affected her, it just did not name the individual, the providers, because those are the medical records. And in the offer of proof, I indicated that subject to impoundment, we will provide those. The court denied the motion for impoundment, so they were not added. But yes, in other instances, plaintiffs choose not to care. Some people don't care if their medical records are in public, and they choose to attach them.
What's the purpose of leaving out the providers' names if those are the people that you're suing, right?
Well, the purpose is that in this case, we're at the beginning of a trial. When the expert reviewed the case, the expert tells you, here's all the people there are potential defendants. Then the lawyers can make the tactical decision, like, I have 7 people that are potentially at fault. I only want to sue 5 of them because the other ones maybe are charities or maybe they are something else.
How do they know who you are saying did what if it's not in the offer of proof?
Who? I'm not sure the question.
The defendants.
The defendants knew because the defendants had the medical records. And then the expert...
But the tribunal.
Yeah, it's the tribunal. How's the tribunal
I agree. In this case, it didn't.
supposed to sort this out?
I agree. In this case, the tribunal could not. Without the medical
You're the
records.
one that impounded, so that's...
If they were impounded, they would, because the expert opinion letter, along with the medical records, provides specificity as to who did what. It defends the PA did such and such.
You're making the tribunal do an awful lot of work. It's kind of risky. I mean, it's your risk to take, but...
We just heard an argument that the tribunal's job is to look to the 4 corners of the offer of proof to determine whether you meet the test to go forward. I think that's correct.
I agree with that.
All right.
And in this
And
case,
so in this case, that standard was not met.
because the medical records were missing. Correct. I agree. Which is why I said I am here one step before your the second argument you heard before me. In this case, without the medical records, I would not argue that the offer of proof was strong enough, even at the court's most recent opinion in the Feliciano case, because without the medical records, it was not there. But because
Counsel, can I go back to Justice Wellhogen's questions earlier? I'm struggling to understand why your expert whose letter lays out a story of potential malpractice, couldn't say in that story, it's all written in the passive voice, such and such occurred, such and such occurred. Why couldn't the names of the providers be in that letter?
It could be. It wasn't in this case. I'm not the expert. I'm not the doctor. I didn't write his letter.
So those names weren't omitted because you're saying they were part of the confidential records and you didn't want the names in the letter. It's just a function of what this expert happened to do.
Correct. In this case, as I said, had the impoundment been allowed and the tribunal found the offer was not sufficient, my client would have paid the bond and go forward. But because in this case, she knew that because the court denied the impoundment, no matter what she did in this case, her medical records would be up to public, so she couldn't prosecute the case. So the issue of whether or not...
No, but there was a step, right? The judge says, you can tailor this. And doesn't the judge also say some of this has already been revealed by the offer of proof, right? The judge says, okay.
Yes, the judge compares medical records with the medical information. The offer of proof and the complaint discuss issues. The source material is what was not included.
Right, but I some of this, you're proving, you're trying to prove negligence on the part of the doctors for particular procedures. And the judge is saying, I understand you may have, there may be some other stuff about your client. Maybe she's had some other medical issues that we want to keep completely out of this. And he's giving you an opportunity to avoid all of that. But you're not even addressing the argument that some of this is already in here, and I want the best evidence of this, and I don't want an impoundment overlay on it. I don't know. You're taking some risks.
We're not trying to prove negligence. We're trying to prove that there's enough to go forward. It's not trial. And in the medical records nowadays, to get that one part that says here's the involvement, unless I produce something that is 17 pages, of which 16 and a half are all blacked out, yes, that is an option. But then what will be before the court is arguing with the defense of what is or isn't properly redacted. I am always of the belief that if the information is out there, you can see all the information. You don't try to hide stuff behind a box, because then we'll get into this arguments that, well, what you blacked out is not what I believe should be blacked out.
You don't dispute that the judge is required to apply the good cause standard, correct?
Correct. No, I don't dispute that the good cause is the proper standard. My argument is that medical records by both federal and state statute should be good cause enough, as they are in many other cases.
Per se.
Per se, if argued for, as this court has held 10 years ago, although in just in a footnote.
What does HIPAA say about medical records in a lawsuit? Does HIPAA provide protections for those?
HIPAA specifically says that if you're going to use them in trial, you should seek impoundment and protective orders. That's what I do in every case. I file for impoundment and protective order. Impoundment deals with how medical records are handled in open court. Protective order handles how they're dealt with.
And you run into a judge who says, I'm going to take the good cause standard, and you tell me what parts of the record should be impounded, and you say all of it.
Especially nowadays, because of electronic medical records, it would be impossible to start redacting, because a single note is going to be a 40-page of medical records. A note that spans less than 24 hours is 250 pages of medical records.
But you started out by saying that you're not advocating for obviating the good cause standard, but you really are. Because if you're just going to say that all medical records, as opposed to what the judge here tried to say is, there might be this universe of medical records that are irrelevant to your claim, and I'm not interested in that. So tailor your argument for good cause as to just the records that you claim are what needs to be impounded. And one of the things you've been doing is, I don't want to collapse these two verticals. The second vertical about the tribunal, again, this seems like it'd be a little bit of an unforced error here, because if your expert comes back and does this narrative but leaves out the potential defendants here, you could always say, hey, you got to put them in. I understand you're not the expert, you're not the one, but you're certainly the one that's engaging the expert, and you know what the law requires, and you could have said, you got to put the names in here. Right? So they're two separate things.
They are two separate things, and for the issue on the first issue of good cause is, if there are records that are not relevant, they're still going to be introduced, because oftentimes you complete the full records. If you start putting just excerpts, at the offer of proof phase, maybe that's applicable, but at trial, you're going to do completeness. Medical records to be certified have to be complete.
No, I'm just looking at our review of what the trial judge did as to the impoundment request. And part of that was giving you the opportunity to say, can you distill this a little bit to give me a little bit more detail about what the concern is and why it is you need impoundment so I can inform my good cause analysis?
And the response was because they're medical records, and the court said that's not good enough. So
Well,
that's why I'm here arguing before the court is
The
that
deficiency in your offer of proof was that you did not attach the allegations of liability, of negligence, to any particular people. It's really hard to show how you showed good cause because the names of the providers are not really confidential. Do you see the problem here?
I understand that the letter itself in this case is not very
So
specific,
you could-
which is why I didn't argue the tribunal stage issues. Had the medical records been impounded, we would likely have paid the bond and moved forward. The issue here is the threshold issue is, do you have to give up your privacy as an injured party just to be able to go in court? Or medical records, which should be confidential and are confidential by both state and federal statutes, should remain confidential when they're in court or at the whim to a trial judge. And as the appeals court, the dissent mentioned, there is no other opinions that the approved denial because 99% of chances they're often approved. And 85% chances the defense never objects because most of them represent medical providers and they agree that medical records should be protected. It's just once in a while you have a counsel that wants to argue every single argument and they'll argue the case. And you have one judge that maybe have a different standard and wants more. And my argument is, and the plea to this court is, medical records alone should be good cause because they are confidential under federal and state statutes. And nowadays, with electronic medical records and the court's electronic access, there's so much information out there that's available that plaintiffs, injured parties should not have to be victimized twice just to be able to pursue a case.
Okay, thank you.
My time is up.
Attorney Pimentel.
Thank you, and good morning, and may it please the court, I'm Megan Pimentel on behalf of the appellees. We've been talking about medical malpractice tribunals this morning, and one of the hallmarks of that is the presentation of an offer of proof. Contained within that offer of proof is an expert letter from a qualified expert that delineates the applicable standard of care of that particular healthcare provider. It also is going to opine as to how that particular healthcare provider breached the standard of care and how that breach of the standard of care caused damages. The medical records provide the factual basis.
Sorry, could you just skip to the, I don't know that we would necessarily reach the particular offer here depending on the outcome of the impoundment issue. So could you start with that issue?
The impoundment issue?
Yes, and could you address the core of the argument that's being raised that medical records in particular are protected under our common law, they're protected by state statute, they're protected by federal statute, providers understand that they're confidential. All those protections exist regardless of the existence of particular stigmatized conditions. Rather, all medical records are subject to this. And I would understand, I didn't see an express concession to this effect in your brief, but I would assume that you would concede that in general, people have a legitimate expectation of privacy in their medical records as a result. Do you agree with that?
Well, I'd say there's two things. In general, if we're just talking not in the litigation process, there is an expectation that protected health information, there is some level of confidentiality that provides.
So you're not conceding that there's a legitimate expectation of privacy generally in one's medical records?
What I'm saying is in the everyday form there is, but in litigation, and that's what we're talking about here, there are specific carve-outs, and specifically HIPAA does provide a carve-out.
Well, HIPAA provides that providers can use medical records to defend themselves, but that's not the question. No one's contending that you can't use these medical records.
But if we play out what the plaintiff asks us to do, if we're impounding medical records, one, it's not just the records themselves, because we have to look at the purpose. Why does he want to impound it? Because it contains protected health information. So aren't we necessarily talking about that protected health information, whether or not the actual record is in there. That's the purpose of what he wants to do. Because if we're looking at the good cause standard, is it something that's intensely personal?
So you don't, I mean, so there's a lot of your argument is taking off from the Superior Court judges saying, you know, I want a more particularized showing of something that deserves privacy. So someone's height, weight, blood pressure readings, this medications they take, all of their sort of regular conditions that they might have that aren't hugely stigmatized conditions. Are you saying that's not enough? Just like I should, if I want to file a medical malpractice suit, I should, as a price of filing that suit, have to display to the public all of my medical records with all of that information if I can't show that I don't have a stigmatized condition?
Well, specifically, what you're putting at issue is your medical care and treatment, and that is not just going to the care that was provided by that particular provider that is being sued, but there's so many other factors that go into it. What was your care and treatment before, and how does that play into the care and treatment that you received? What are the ensuing damages
Yeah,
of
but
care?
but all of that isn't off limits to you. It's not off limits to you. It's not off limits to the judge. And whether or not somebody who's not sitting on the ultimate jury gets to review that, why do we want them to be able to see that? Because that's really what it comes down to. When you impound it, you get it, the judge gets it, the tribunal can get it, everybody can get it. That needs to get it in order to make their initial threshold determination.
I think if we take a step back and we look at judicial integrity is rooted in public access, right? And so it is a public courtroom here today that everybody is sitting in, and the purpose is to have access to judicial records. So impoundment
No, because we have all types of situations in proceedings when we're going to evaluate somebody's Fifth Amendment protections. We close the courtroom. When we're going to evaluate whether or not, in the rape shield context, whether or not information, we close the courtroom. There are all kinds of compelling reasons, and I understand those are constitutional concerns, but what we're talking about here is whether or not there's a legitimate interest in the public knowing what this potential plaintiff's medical history is. And why do we want people to know about private medical information that isn't even yet ripened into a case?
Well, it doesn't make sense to impound it at a certain issue and then to have it be not impounded at the trial court level when we're actually.
But that happens every day. We earlier this morning, we had an argument in a juvenile case. None of us spoke the juvenile's name, and there's a lot of information about that juvenile that the people here were not privy to. Nevertheless, they got to hear us discuss the issues and debate the questions at issue. And the same thing would happen in this case and happens in every other case where there's private medical information that's impounded, so the public can't just go and look through all of her medical records, but the parties can discuss in open court the core of the issues that do involve some medical information.
Well, respectfully, Your Honor, the names were impounded. So when the plaintiff files a medical malpractice action and names specific individual providers, that provider's reputation in their professional reputation is on the line. Did they provide proper medical care and treatment to that patient? And I would submit that it absolutely should be available to the public for the public who is a
So there's a
consumer,
public, so you're arguing there's a public interest in the public independently scrutinizing her medical records for the public to make their own judgment as to whether the providers, even before this lawsuit has taken place.
Well, the lawsuit is taking place when it's submitted into evidence that the offer is submitted as.
Well, this is a really preliminary stage because this is just the tribunal.
Well, the doctor has a right to defend himself even at that preliminary stage, both with the tribunal and.
How would the doctor be heard? By the way, this is a basic question. Are these tribunals open to the public?
They are, just like any other judicial.
So it's a public session, and he's arguing that all this should be impounded. So I guess practically, how does that work?
So practically speaking, if we are to carry this out, we're in essence creating secret courts, right? So that we would have to have the parties come in for that particular case. It would be heard. It wouldn't be open to the public because we're revealing protected health information.
No. He's not impounding the proceedings. He's impounding the source material.
But why is he doing that? He's doing that because he's saying there's information that we're talking about that's contained in that source
Right.
material that's protected. So how, you can't allow public access to that because the point of trying to compound it.
Just back to Justice Stewart's point and what we've been saying all morning, and I think as your brother has said, you can still talk about it. He's just trying to protect the source material. So at the hearing, you can talk about it. People can be cross-examined. They can be examined. All of the other stuff. The only thing we're protecting is the public's right of access of going and grabbing a file or seeing it online.
That information has already been disclosed to the public, whether it be in the expert's letter.
So her blood pressure, her weight, the medications she's taking presently, those would all be in her records, and those are not in the offer.
They're calling out what records they're putting in the offer of proof, and presumably, because we as the defense don't have the ability to submit extraneous evidence, so they're calling out the records that are included with the offer of proof, supporting the, talking about the care that's at issue and supporting their expert's opinion. So at that
And
level,
if they
you're
do-
not putting in all of the records.
And if they do that inadequately, then they don't get the benefit of a favorable ruling by the tribunal. And that's what happened here. They can still make that choice.
Well, for this particular case, really what the failure was and what we need to look at only is the expert letter, which was wholly deficient in this case, because this court has said you cannot group all of the providers together and have these generalized allegations and conclusions.
And I don't think that the plaintiff's counsel is disagreeing with that. I heard essentially an acknowledgement that the offer of proof is deficient. I don't think that's the issue that he's really trying to litigate on behalf of his client. He's trying to litigate simply whether he was required to do something other than show that the documents he was seeking to have impounded were medical records in order to satisfy the good cause standard. That's what I think he's arguing.
I think part of what I heard from him this morning was that because he was not allowed to have the medical records as part of the offer of proof because there was not an impoundment, then the expert letter was deficient. The whole offer of proof was deemed deficient. Had he been able to have the medical records as part of the offer of proof, then it wouldn't have been found deficient. And I submit whether or not there are records, it was deficient.
Was the timing, the impoundment issue was decided before he filed his offer of proof?
So you're required to file your offer of proof within 15 days after the defendant files their answer. What he had noted when he filed that offer of proof is, depending on what the impoundment order says, I will submit it. Even after the impoundment issue had been denied and he had appealed it up to the single justice and it was again denied, he never submitted any of the medical records.
So from a narrowing perspective, because, can we write a decision that you think is correct in which we say, look, because this offer of proof did not contain the names of the people, the judge's approach to the impoundment was within his discretion? I'm just trying to get a sense of, is that the problem? Because the names were not included, then the judge had a reasonable right to request the record so that somebody can decide who the particular providers are. I just don't know if there's a narrowing here.
Sure. Again, in addition to the names, that was just one issue with the expert's letter, but also with the expert.
It's pretty detailed besides the names given.
In terms of actually the narrative of the care and treatment, but what is missing from that expert letter is what was the standard of care required of each of those individual providers? And what you have to look at here is there's several different specialties that are involved. It's nursing, it's emergency medicine specialists, it's physician's assistants, and there's a surgeon. There is a different standard of care that applies to each one of those providers. And what the plaintiff's expert fails to do is even tell us what that standard of care is. What was expected of each of those providers at the time that they cared for this patient? We don't know. It's not contained in the expert letter. So how are we to evaluate whether or not they fulfilled those duties?
Just to go back to, just to go back to the issue about impoundment, I think he said that they would have been willing to pay the bond and move forward, except that the records would not be impounded, and that was not acceptable. So I'm not sure if whether the offer of proof was good enough matters at this point. So I'm trying to figure out what we're being asked to decide.
I'm with the chief on that. I mean, so if you take our three concerns, are you saying if we were to find that the judge did not abuse his discretion or make any errors with respect to the decision on the impoundment, does that obviate the discussion about whether or not the offer of proof was adequate?
Well, if we take the low standard and we just looked at the expert letter without the issue of impoundment, we look at specifically the expert letter, and that's deficient on itself for the two reasons I elucidated. So you don't even need to get to the impoundment issue to find that this offer of proof in this case was deficient.
Okay.
But if we concluded that the judge abused his discretion on the impoundment order, then what's the solution? Remand for?
No, essentially, again, my argument is whether or not the records were included with this particular offer of
Would
proof.
still fall
It's still deficient because it's not only were people not named at all, but we don't even know what the standard of care is to evaluate whether they met it or did not met it, because it's not elucidated in this letter.
How can we say, though, that if we think that the judge abused his discretion and that she should have been allowed to file the medical records in impounded form, without the benefit of seeing those records ourselves, how could we conclude that she loses even with the benefit of the records?
And I'm sorry, I missed the last part.
How could we conclude that she loses even with the benefit of the records where we don't have them in the record?
Because we have to look at the expert letter. So under the case law that's well established by this court, it has to lay out what the expert has to tell you. What is the standard of care?
But the
of
expert
each of
talks
these?
in broad swaths about what particular providers did, doesn't name them. The records are the answer key to fill in the blanks.
It's not, though, because we don't know
That's what
the...
Judge Rubin says, but
Yeah.
And respectfully, I disagree, because as I mentioned earlier, there's different specialties. There's different things required of a surgeon than would be required of a nurse. And so how are we to evaluate when this expert letter doesn't tell us what was expected of each one of them and how they failed to meet it?
I know you mentioned case law, but are you also relying on the rule? Is this also something that Rule 73 speaks to?
I don't think, Rule 73 doesn't necessarily speak to this particular issue that we're talking about.
About the level of specificity that's necessary?
There's case law on that point. Yeah.
Do you want to address the fact that our uniform rules of impoundment say that medical records must be impounded?
They don't say that they must be impounded. I think simply what that form looks at is that is a category that may be, depending on if it meets the good cause showing, and there's a balancing test that has to be done. So it's not just weighing out the patient's interests, it's also weighing out the defendant, physician, or healthcare provider's interests as well. And that's what the court has to do. And to overturn that, there must be an abuse of discretion. And where the plaintiff here failed to even avail themselves of the vehicles that we already have in place in order to protect records that contain personal information. I don't.
Are you skipping over one though? Because I couldn't see in the record where were the arguments on behalf of the defendants that their interests counterbalanced or overweighed?
I think that was in our opposition that we had submitted on the motion for impoundment, that we had talked about that. And
I thought that opposition only argued that, mistakenly, that if the records were impounded, the defendants wouldn't have access to them. I thought that was the sole basis given in the record.
I'm sorry.
I thought that was the sole argument as I read it. Can you point me to a place in the opposition that makes any argument other than if these are impounded, we will not have access to them, which is incorrect?
Yeah, that's why I'm asking you, because you're saying that there's this balancing. Well, where was the counter argument about the interest in the doctors?
But we never even got there because he didn't make any showing of good cause at all. And Judge Gordon invited him to do so. So we never even got to that level at the trial court level.
I thought relying on the uniform rules of impoundment and saying that presumptively they should be impounded.
But he has to show good cause, and that's what Judge Gordon invited him to do when he denied the underlying motion without prejudice.
His opening motion cited both HIPAA and state common law and statutory law. So he'd already provided a basis that the records were private.
In what we were saying is that HIPAA already provides an exception that they are not private when it's placed at issue. And there's specific statutory.
So is your position that that HIPAA just doesn't apply once there's litigation? That's not what HIPAA says. HIPAA
No,
says
that's not
that
what I'm saying.
HIPAA specifically just gives you the ability to use the documents in the litigation, which makes a lot of sense. But that's different from saying that there are no privacy interests with respect to those
There
documents.
absolutely are privacy interests, and if there are particular privacy interests that the patient wants to put forth, then they have to make a showing of what those privacy interests is, because again, impoundment is the exception, it's not the rule, and I think that's what we have to go back to.